You've just used an AI tool to create a logo, draft a patent specification, or write an entire article. It looks great, it's ready to go. But here's the question nobody asks until it's too late. Who actually owns it? Is it you? Is it the AI company? Is it nobody? Today we are breaking down the intellectual property rights on AI-generated works, what the courts have said, what the law currently allows, and what you need to do right now to protect yourself. Before we begin, a quick but important disclaimer. The law on AI-generated IP is unsettled. It varies from country to country, it is evolving rapidly, and given how novel this technology is, it will continue to develop in the years ahead. Let's start with the foundational principle that runs across almost every jurisdiction. The single most important factor in determining IP ownership of AI-generated content is how much human intervention was there. If a work is generated entirely by AI, no human creative input, no shaping of the output, no skill or judgment applied. The person for it generally belongs to no one. It falls into the public domain. No copyright, no protection. But if a work is a mix, some elements generated by AI, some genuinely authored by a human, then the human authored elements that meet the threshold for protection under copyright law can be owned by that human. So the short answer, the more human creativity you put in, the stronger your claim. Let's look at the United States first, because it has produced some of the most significant legal developments. In the case of Thaler versus Perlmutter, decided by the District Court for the District of Columbia, the court reaffirmed a principle that is now central to US copyright law. Human authorship is an essential element of a valid copyright claim. The court upheld the US Copyright Office's decision to refuse registration for a work generated entirely by AI with no human authorship involved. This wasn't a surprise. In February 2022, the US Copyright Office had already released a policy statement making its position clear. The connection between the human mind and creative expression remains essential for copyright protection. The takeaway for the US? There has to be sufficient human contribution for copyright to attach. Now let's move to patents, and the question gets even more pointed. Can AI be listed as an inventor on a patent? In the United States, the answer is a firm no. In Thaler versus Vidal in 2022, the Federal Circuit ruled that only natural persons can be listed as inventors on a patent application. And in a further development, the US Supreme Court declined to hear a challenge to the US Patent and Trademark Office's refusal to grant patents for AI inventions. The case involved a scientist whose AI had independently created a unique prototype, a beverage holder and an emergency light beacon, entirely on its own. The justices rejected the appeal, affirming that patents can only be issued to human inventors. It's not just the US. The European Patent Office and the UK Intellectual Property Office take the same position. The UK IPO explicitly refused to grant a patent on the basis that the inventor must be a human or a company, not a machine. For those of you in India or working with Indian entities, the position is consistent with global trends, though it comes from a different statutory foundation. Under Section 2D of the Copyright Act 1957, the grant of copyright has always rested on the concept of a human author, a legal, natural person. The Supreme Court of India, in the landmark case of Eastern Book Company and others versus D.B. Modak, held that in order to copyright a work, a degree of originality and intellectual effort is necessary. There must be a human mind at work. Importantly, and this is critical for Indian practitioners, there is currently no specific provision in any Indian IP law for AI-generated works. The existing framework simply does not contemplate it. So in practice, under Indian law today, authorship and ownership will depend on two things: the terms and conditions of the specific AI tool you used, and whether in giving your prompt you exercised skill, judgment, or creativity in shaping the final output. Here is something most people completely overlook. Even if the law grants you some basis for ownership, the platform you used may have something to say about it. Every AI tool, whether it's a writing assistant, an image generator, or a code tool, comes with its own terms of service. These terms may grant you full rights to the output, allow you use rights but retain ownership for the platform, impose restrictions on commercial use, vary depending on your subscription tier. So before you publish, monetize, or assign that AI-generated work to a client, you need to read the fine print. And speaking of who could own the output, there are actually 4 possible claimants worth considering. The user who entered the prompt, the developer of the generative AI software, the person or team that trained the model, the copyright owner of the material used to train the model. In most cases today, it comes down to the first, the user, but only if they've contributed sufficient human creativity and subject to what the platform's terms allow. So what does all of this mean for you practically, especially if you're a business or a professional using AI tools? Here are 5 things you should be doing. 1. Document human contribution. Maintain clear internal records of the human decisions, creative choices, and intellectual contributions made along the way. This documentation could be essential if your ownership is ever challenged. 2. Conduct IP audits. Map your workflows. Identify clearly where AI is being used, what outputs are being generated, and what rights you are relying on. 3. Update your internal AI policies. You need a policy that governs how tools are used, what can be generated, and who reviews outputs. 4. Address IP in your contracts. Include representations and warranties confirming human authorship and originality of the work. Do not assume. 5. Maintain patent documentation. If you are using AI in product development, keep rigorous internal records of human involvement at every stage. Let's bring it together. AI-generated works occupy a legally grey space, one that courts and legislatures are still actively working through. The core principle across jurisdictions is this: human creativity is what IP law protects. The less of it you can demonstrate, the weaker your claim. Review the terms of the AI tools you use. Document your creative process. Build IP protection into your contracts and your internal governance. The law will catch up with the technology, but until it does, the burden is on you to protect your work. If you found this useful, like and subscribe. We cover IP, contracts, and legal strategy for the modern professional.